I met.
That's a public game, so that's good public. So you can see if I change it.
Yep, we got it. Okay, great.
And then I'm gonna minimize this. But we're gonna need to share the screen. So I'm gonna drag this over there. Share. Selection.
Yeah.
We're doing that.
Yep.
Okay. Okay, and I'm gonna drag these controls on this one. So I'm gonna drag the other one.
Okay. All right.
I'll see you first.
Thanks, man. Okay.
And his second prayer was facing.
Good morning.
Morning.
So for those of you who don't know, I see a couple of repeat offenders from last semester. For those of you who don't know, I'm Reed Krell. Welcome to Civil Procedure 2. I'm going to start with some administrative stuff. And the first administrative thing I'm going to do is say, if you are seated in the back row of any section, please get up and move down. Here's the reason for that. That is not applicable, right? If you cannot navigate your way to further down. We are reserving the back row for folks who may need to come and go. These are folks who may need to, may have a job interview, or maybe you have kids that are sick and you're expecting a phone call, or you have elder care responsibilities, or God forbid, you have children and your child care has fallen through and you have to bring your kid to class. So if you can navigate your way farther down than the back row, do so. If you are dependent on a mobility aid that makes stairs difficult, don't worry about it. Okay. Second administrative thing, I've passed around a sign-in sheet. This is not how we will normally take attendance, but this is for today so that I know who's here. The other thing I'm going to be passing around is a seating chart. Because yes, we are going to have assigned seats because unfortunately, there's too many of you for me to feel confident that I will learn to attach names and faces relatively quickly. So I will be attaching names to butts and seats. So thanks very much, sir. All right. Other administrative things that we need to talk about. You were asked before the first day of class to complete the icebreaker quiz on B2L. This is the one that's under getting to know you. Some of you have not done this. Some of you may think you have and haven't, so double check. Because there's several students who have attempts listed but have not completed it. This isn't just a silly exercise for those of you who haven't done it, okay? The purpose of this is for me to hear from you and about what your needs are with this class. So for example, a number of folks, and I'm not going to name names, have mentioned struggling in Civ Pro 1. Some folks have sort of put the responsibility for that struggle on themselves. Others have put it on the faculty member who taught them. Some have put it on the subject matter itself. For whatever reason, if you struggled in Civ Pro 1, that's important information for me because that helps me understand who may need more outreach, who may need greater guidance as we're working through the materials. So this is an opportunity for you to benefit by letting me know what's going on with you. Other administrative things. So Masks. Not required as of right now. Encouraged if you are so inclined. I'm masking because I flew on Sunday. And so I have been exposed to any number of respiratory nasties that I do not want to give to all of you. So once I am sort of past that window of contagion, I will also be unmasking. However, I do reserve the right to, at any point, impose a mask, a requirement to mask in our class. And I also reserve the right to absolutely not tell you why. So, unfortunately, that is me exercising one of the few prerogatives as faculty that I have, which is that I do not necessarily have to explain myself. Other administrative matters. We will be recording our first few class sessions to support students in this class who, due to various personal issues that are none of your business, have not managed to join us at the start of the semester, but will later on. So I say this in all love and respect. And I also say this because I've been at other institutions where not saying it was a problem. If you do not consent to being recorded and having your recording uploaded to YouTube, which is where I post class recordings, please drop the class. Like, this is not negotiable. By continuing in the class, you have consented to being recorded and having those recordings uploaded on YouTube. All right. What questions do you guys have about administrative stuff? I'm not going to waste your time going through all the minutia of the syllabus because you are all law students, and so you are all capable of reading and understanding the English language. And so the material in the syllabus is not anything that I do not believe you can comprehend. So, but what questions do you have up to this point? I will answer questions about the syllabus today, and I will answer them substantively without just saying, well, maybe you should read the syllabus. So, questions? Yes.
Do you want us to submit our DRQs anywhere or just bring them to class?
So the answer to that is you will submit DRQs at various times over the course of the semester. You will be advised when those happen. So if you are not advised that you will be submitting them on a given day, just bring it to class. Yep. Okay. Yes.
The makeup of the midterm and final, is it going to be essay based or multiple choice or?
The syllabus discloses this, but as I promised, I answer substantively today. The midterm will be MBE style, and the final will be MEE style. So midterm will be multiple choice, final will be essay driven. Both will be closed book, closed notes. And the syllabus talks about that in a little more detail, but the short version is whether you like the bar exam, are indifferent to the bar exam, hate the bar exam. Right now, the bar exam is what we use to gatekeep the profession. And we want to empower you to be as successful on the bar exam as possible. One of the ways that we can do that is by giving you opportunities to engage in assessments that are similar to the bar exam. Okay. So that's the idea is we're doing this like the bar exam to help you sort of build up those intellectual muscles. And hopefully what that means is that, you know, in July or next July or next February or whenever, you will be well prepared for succeeding in the most important and most stupid test you'll ever take in your life. So, what other questions? Yes.
So if you still don't have the book, because it's on back order, what?
Okay, so, I've actually gotten a couple of emails from folks who, have sort of like pre-passed because they don't have the book. And I'm going to put this policy in place, right? If you do that, if you contact me and say, hey, I'm not prepared for class because I don't have the book, or later in the semester I'm hungover, or I had a family emergency, or whatever, right? What I am going to do is sometimes there are questions that are kind of gimmies, right? Whether they're DRQs from the book or they're follow-ups that I'm preparing as I put the class together, sometimes there are questions that don't really require a lot of thought and preparation. I'll reserve those questions for students who have pre-passed. The idea is, if I ask you the question and you're able to go, oh, I can answer this, and you answer it, great. Then we don't have to count your pass against the total that you're allotted for the semester. If after asking the question, you go, ooh, I still don't feel comfortable with that, then you pass, we honor the pass, and we count it against you. So, that's the plan. Today is going to be a little more flexible. We're not going to count passes against you today because I know that the Ichabod shop has dropped the ball, and not all of you have the books, and not all of you had access to the assigned readings. So for today, if you need to pass, then pass. We'll move on. Okay. The other thing is, like, you guys don't know me yet, so you don't know that you can communicate with me outside of class, and I will take that into account in how I manage the classroom. Okay. Where is the signing sheet? Okay, can I get it back? Is there anybody who didn't get a chance to sign it? Yes, okay. Can we make, whoever said yes, can we make sure that the signing sheet gets to them? Someone?
You didn't get it.
I need you to raise your hand if you didn't get the signing sheet. Like, let's not play this, try and find voices. Okay, everybody signed in. All right. Thank you very much, sir. Okay. So now I won't call on folks who aren't here. All right. So, last chance to ask administrative questions before we get started. Yes.
So if I'm understanding your email yesterday correctly, you signed the 10 DRQs, and then it's our responsibility to kind of look at the casebook and find out, what we need to be on top of for understanding the DRQs.
Right. Okay. So what I will tell you, this is not necessarily apparent from today's reading, but as we progress, you will see more and more. The book, by and large, gives you what you need, right? As we move into later chapters, you will see that there is significant reading associated with the DRQs sometimes, right? But sometimes it's more like what we had today, where it's just sort of a rapid fire. Here's a bunch of questions with very minimal reading attached to it. Okay? So last step, questions? Going once, going twice. All right, let's move it along. So we're starting with supplemental jurisdiction. And sorry, I'm just getting this here so that I have the time. Well, I thought we had supplemental jurisdiction. All right, well, we've used two clickers that don't work. Let's just see if this one decided to work. Nope, all right. Okay. So, question one, what does the word supplemental mean to you? Mr. Adams? Yes.
I would imagine it means additional.
Hey, yeah, right? Kind of a gimme, right? Ms. Velasquez, what does it mean to supplement your income?
If you
Thank
said
you.
you were gonna supplement my income,
Yes,
that you were going to provide me sufficient income so I didn't have to fight.
okay. Mr. Olive?
Well,
Ms. Olive, I apologize. Can you maybe give us a different definition of what it would mean to supplement your income?
Possibly pair it with some sort of benefit in addition to the income you already received.
Mr. Van Diest, what do you think?
Adding additional income to what you already have.
Right. Okay. So if I'm going to supplement your income, I'm going to take the income that you already have and I'm going to put more into it. Right. So, and the reason why we're looking for that answer specifically, right? So for Ms. Velasquez and Ms. Olive, right? The reason that we're looking for that particular answer is that supplementation doesn't ask about sufficiency, and it doesn't ask about, sort of the type of income, right? So the income versus benefit distinction that Ms. Olive makes. So we're not interested in anything except the notion of this being additional. What other types of situations do we talk about supplementation? Yes.
I think the duck, the Aflac duck, so like supplemental insurance, for example, it's not a replacement for insurance, but you have insurance, and that's something that sort of fills in the gap. It's in addition to.
Sure, right? So you have your usual health insurance, and then you get some sort of supplement from, as Mr. Hoover points out, the Aflac duck. Anything else? Yes.
I would say like class, if someone were, like a teacher were to add like a supplement article that you could read to help you understand the concept, or
Right.
like our procedure book or anything.
Right, supplemental readings in classes. Okay, so the idea, right, we're going to be working with this idea of something that's an add-on. Okay, and that's going to be sort of consistent throughout our discussion in this chapter. We're going to be talking about jurisdiction that's an add-on to what we already understand the bases of jurisdiction to be. So moving on. So a client walks into your office and tells you a story which indicates that the client may have a claim against their employer for violation of a federal anti-discrimination statute based on the employer's failure to promote the client. I will tell you, as a former employment lawyer, this fact pattern does not induce me to take the client. But that's a different class. So, Ms. Baral. Yes, and please, if I am mispronouncing your name, please correct me. And I say this to Ms. Barral and to all of you. If I am mispronouncing your name, let me know, because you are entitled to and you deserve to be called by the name that you actually want to be called by. So, Ms. Barral, given the fact pattern up on the screen in the DRQ, may this suit be brought in state court? Okay, Mr. Van Hee, why can it be brought in state court?
Right here.
Oh, thank you.
It could be brought in state court because state courts in general subject matter jurisdiction.
Yeah, right. State courts, in most cases, can hear any case, including cases involving violations of federal law. Okay. Next. Same fact pattern. Okay. Ms. Barnett. Yes. Can this case be brought in federal court?
It depends on whether or not there's a grant.
Okay.
Based on these facts, I would say no, because we don't know.
Okay. Mr. Thompson, do you agree?
I think it could be brought in federal court
Why?
because it's a federal claim.
Right. Okay. Think back to, as you can see from the title, right? We are reviewing subject matter jurisdiction. Okay. And we remember from CP2 1, 28 USC 1331 allows federal district courts to hear claims arising under federal law. Okay. So, yes, this suit on these facts can be brought in federal court. Okay. All right. Moving on. After doing some more research on the client's case, you discover that the same facts which support the suit against the employer for violation of a federal anti-discrimination statute also support a claim for violation of a state anti-discrimination statute. Assume that you elected to sue the employer based solely on the employer's violation of state law because the federal statute required a higher burden of proof. May this suit be brought in state court? Mr. Booth? Yes.
Yes.
Okay. Why?
Subject matter jurisdiction.
Right. It's essentially the same answer as the first question involving this fact pattern, right? Is that state courts can hear claims sort of regardless of their source. There are exceptions to that. We're not going to talk about the exceptions, but as a general matter, state courts can hear all claims. All right. So now, Mr. Strawman, may this suit be brought in federal court? Mr. Strawman.
So it's strong with a good talk.
Strawman, okay.
Personal jurisdiction can be satisfied if there's complete diversity regarding the subject matter jurisdiction.
I'm sorry, say that again a little more slowly.
Personal jurisdiction.
Okay, I'm going to stop you right there. Personal jurisdiction, completely not relevant to this question. Okay.
Wow.
This is a subject matter jurisdiction question. We're going to talk about personal jurisdiction in a couple of weeks.
All right. Regarding subject matter jurisdiction, because there's a choice of law issue, the Geary doctrine will apply.
Nope.
Okay.
Okay. This is much simpler than you're making it. Okay. On these facts, as they have been presented, may this suit be brought in federal court? Ms. Brand.
I put yes, but I said supplemental jurisdiction applies
Okay.
because you can combine the claims since they arrive. Yeah,
But what does the question say about which claim is being brought?
the state.
And so does supplemental jurisdiction apply?
In my understanding, I thought it would, but. I
Why
don't
would
think
it?
so. Because I thought you could combine the state and the federal claim into one suit.
You're not wrong. But that's not what the question's asking, right? So what is the question asking?
The state.
Right. And given those facts, does supplemental jurisdiction apply? Right. Okay. So, Ms. Stewart, may this suit be brought in federal court?
No,
Okay. Why not?
they're not bringing,
a federal claim, it's just a state claim, so the federal court doesn't have original jurisdiction.
There's no federal question jurisdiction. Exactly right. Okay. Now, some of you may have said, yes, it can be brought in federal court if the parties are diverse, if the amount in controversy is over $75,000, right? Bringing in diversity jurisdiction. That is absolutely correct, as long as you recognize that the facts that would give rise to diversity jurisdiction not stated one way or the other. Okay. So if diversity jurisdiction is present, then yes, this claim may be brought in federal court. But without those facts, no, it may not. Exactly right, Ms. Stewart. Okay. All right. Moving on. We're going to assume the same facts as question 3, but instead you want to combine the violation of the state law and the violation of the federal law claim into one lawsuit. Ms. Brand.
Yeah. Yes.
Read 1367A, but not any other part of the statute yet, and answer the following questions. And so, for reference, we have our statute. May this combined suit be brought in state court? Mr. Brown.
I say yes, because the state still has that general original jurisdiction.
Absolutely right, right? So state courts entitled to hear cases sort of regardless of the source of law. So unless you're dealing with one of the rare exceptions where federal courts are granted exclusive jurisdiction, the one that comes to mind is the Voting Rights Act. But unless you're dealing with one of those rare cases, state courts can hear federal claims. All right. Now, Ms. Simmons, may this claim be brought in federal court?
You, Mrs. Simmons?
Mr. Simmons.
Oh, you're fine.
I apologize.
No, you're fine.
So, Mr. Simmons, may this claim be brought in federal court?
Yes, as long as they stay in federal claim, right, and stay on.
Right. Okay. So, district courts shall have supplemental jurisdiction over all other claims that are so related to claims in the action within such original jurisdiction that they form part of the same case or controversy under Article 3, right? So the question becomes, right? That does the state claim coming from the same facts mean that these claims are so related that they form part of the same case or controversy? Okay. So the key piece here is that while we are working in this chapter, right, while we're focused on supplemental jurisdiction, we are focusing ourselves laser-like on the relationship between other claims and claims for which original jurisdiction exists. Okay, so 1367A provides that federal courts can hear claims over which normally they have no ability to hear. Okay, these are claims that if you brought them standing alone, the federal court would go, sorry, go home, right? Dismissed without prejudice. Refile in state court. But if you have a claim that the federal court can hear, you can hang on it like a Christmas tree, any other related claim, so that the same court can adjudicate all of the disputes arising from the same set of facts. Okay? Now, one of the things that's important for us to discuss at this point is the statute makes reference to the fact that claims form part of cases and controversies. So let's drop back, take a look at the bigger picture for just a second. We're going to look at the text of the Constitution. So we're not going to get too far out in the weeds of this. The judicial power shall extend to all cases in law and equity. There's our old friend equity. Arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. Okay? So, does the judicial power extend to claims, or does it extend to cases and controversies? So, Ms. Caballero.
Yes, I'm here.
Yes. Does the judicial power extend to claims or cases and controversies?
I would probably say claim.
Okay, why?
Well, I think,
What does the text say? I know the feeling. I know the feeling. I take off my glasses and you all just turn into blobs. So,
It does say 12 cases and then the controversies in which the US shall be a party.
right.
Yeah.
So, let's come back to the statutory text, right? The district court shall have supplemental jurisdiction over all other claims. So these are claims that do not come with a grant of federal jurisdiction that are so related to claims that have that jurisdiction. So in the hypo that we worked through before involving our anti-discrimination statute, what's the other claim? All right. What's the other claim, Ms. Silva?
And with the last typo, question number 4, right?
Yeah.
So we have the federal and then the other is the state.
The other claim is the state anti-discrimination claim, correct? All right. Mr. Cruz, what is the claim that includes federal jurisdiction?
Assume the anti-discrimination.
They're both anti-discrimination claims. Right. Okay. All right. So we put these two claims together, and because they arise from the same set of facts, they form the same case or controversy under Article 3. Okay. All right. Last question on this particular DRQ, and it's a doozy. So, Ms. Musseter, assuming that the combined suit was brought in federal court, what would be the alleged basis of subject matter jurisdiction in accordance with Rule 8A1?
So basically, the federal court has supplemental jurisdiction under 28 U.S.C. 7A. That would be what you state in your
Well,
claim.
I mean, that's what you would say related to the state anti-discrimination claim. If I'm the defense lawyer, what do I do with that jurisdictional statement? Ms. Duncan, what do I do with that jurisdictional statement if I'm the defense lawyer?
And return it back to them and ask for more plain and statement.
I mean, I file a motion to dismiss. Never mind more definite statement. That, I mean, yeah, okay. The probably the plaintiff amends in response to the motion to dismiss. But they might not, they might fight me on it, and boy, I'd love to win that case. So Ms. Duncan's right that the jurisdictional statement provided by Ms. Mussiter is insufficient. How do you amend? Ms. Morgan, how do you amend the jurisdictional statement? Yes.
You would say that the court has subject matter jurisdiction because it's a violation of a federal statute.
Exactly. You have to state the basis of jurisdiction for the claim that the court has jurisdiction to hear as well. Okay, so Ms. Mussiter, you didn't say anything wrong. You said something incomplete. Okay, so what Ms. Mussiter said related to the state law claim, absolutely correct. But supplemental jurisdiction cannot stand alone. It has to come with some form of grant of federal jurisdiction. And so your jurisdictional statement has to assert jurisdiction both for the original claim, right, for the Christmas tree, and for the supplemental jurisdiction claims you're hanging on it. Okay? So, great job. Okay. Moving on. A lot of the rest of what we're going to do in this chapter is going to be looking at two claims and sort of going, well, how related are they? And the standard for that comes from United Mine Workers versus Gibbs from 1966. And this is a phrase, I think I've heard it like a couple of times, common nucleus of operative fact. So that's what we're looking for when we're comparing these claims. Do they come from a common nucleus of operative fact? Now, here comes probably the most off-the-wall question I've ever asked in a class up until today. Explain supplemental jurisdiction in terms of an ice cream cone and sprinkles. Mr. Elias. Yes.
I guess the ice cream cone would be the state law claims, and the sprinkles be the federal law claims, or,
Okay.
you know.
Ms. McHenry, do you want to take a stab at it?
Like the ice cream cone can hold ice cream, and then the sprinkles supplement ice cream.
Okay. Ms. Feldkamp, do you want to?
So the ice cream cone can stand on its own, so that's the original jurisdiction for like the federal claim, and the sprinkles are like the supplemental jurisdiction, so they're so related that they can be added on it, but they can't stand on their own.
Right. Let me put it this way. If you are making a meal out of sprinkles, please go to therapy. If you are making a meal out of an ice cream cone, okay, like, shouldn't make a habit of it, but like, I understand, all right? You cannot eat just sprinkles, and a federal court cannot resolve only claims for which they have supplemental jurisdiction, okay? So, okay. Now that we've had our fun, this is going to get a little complicated. All right. I want you to take a look at the texts of rules 13A and 20. The Federal Rules of Civil Procedure texts are here on the screen for you. Okay. I would like you to take a minute. And if you have not already drawn a Venn diagram that compares the relationships between claims in these two rules to 1367A, please do so now. And I say I'm giving you that time now because I remember being a law student. Okay. Drawing a Venn diagram, like I would look at that and go, okay, this is something I'll do like later. Okay. So take a minute. All right. Mr. Heiston, please come to the board and share your Venn diagram with the class.
Yeah, I don't have one. So I would love to be able to engage in this part, but I'm gonna have to use one of my passes on
Okay.
Thursday.
All right, no problem. Mr. Massey, you would please come to the board.
I was in the middle of working on it.
Well, give us what you got. It's fine.
So 13A talks about arising out of the same transaction or occurrence. That's where that would go.
Okay, so Venn diagrams are supposed to demonstrate relationships. And when you draw them, so I want to and I'm not saying this is a little bit of a criticism, but it's not, I don't expect, this isn't something that I expect you guys to have learned already. But when you draw these things, right? If you draw overlapping circles, what you're implying with your diagram is that there are cases where Rule 13A applies that Rule 20 does not, and vice versa, right? Is that the case?
Not sure. I didn't think it through very well. Like I said, I was in the middle of going.
I understand.
through it,
I understand. All right.
I can be your scribe if you like.
I can do you one better. So, this is what it actually looks like. Little bit of a trick question, because when you say Venn diagram, you are expecting these overlapping circles, right? But in situations where one category is completely contained within another, the appropriate Venn diagram is nested circles. And so in this case, Rule 13A allows for joinder of claims or counterclaims that arise out of the same transaction and occurrence, and these are compulsory counterclaims. Rule 20, which is the joinder of claims rule, allows for joinder of claims that arise out of the same transaction occurrence or series of transactions or occurrences. You can see how that's broader than the same transaction or occurrence. And then even more broader than that, 1367A allows for the combination of claims that derive from a common nucleus of operative fact. Okay? So I hope that this exercise helped you learn something, A, about conceptual mapping, but also about supplemental jurisdiction. Okay? But the key piece of this, right, is that if you have a state law claim that satisfies Rule 13A for compulsory counterclaims or Rule 20 for joinder of claim, for permissive joinder of claims, you automatically clear the 1367A hurdle. Okay? All right. Check the time. Okay. I'll pause here. What questions do you guys have so far? Yes, Mr.
I
Hodgson.
just want to make sure I understand what I'm looking at here. So any claim that springs from Rule 13A or Rule 20 is going to be part of supplemental jurisdiction and will be attached to a claim where original jurisdiction exists?
Right. So you have your original jurisdiction claim, and then attached to that, you have a compulsory counterclaim. So the defendant has a claim in response that arises out of the same transaction or occurrence, but it's a state law claim. That's Rule 13A. That is obvious. That's a compulsory counterclaim. And because it's a state law claim, there's not automatically original jurisdiction, but it meets the 1367A requirement. Okay? And similarly, right, you have filed your original jurisdiction claim, and you have some other claim that you want to join that meets the Rule 20 requirement for joinder of claims. That also, even though it's a state law claim and has no original basis of jurisdiction, that also meets the supplemental jurisdiction hurdle. Does that answer your question?
Yes.
Okay. What other questions? Yes.
Will these slides be posted to CP2?
I am torn on that. Here's why I'm torn. Okay. On the one hand, almost all of these slides are just the DRQs. This is probably one of like 3 or 4 slides that are not just the text of the DRQs right out of the Facebook. On the other hand, I recognize that like having these slide decks is helpful for you guys as an extra tool in your studying, even if it doesn't necessarily give you a lot of added value. Where I am leaning is that I will post these slide decks once we complete each chapter. So when we finish chapter 12, the slide deck for chapter 12 will get posted. When we finish chapter 13, the slide deck for chapter 13 will get posted, so on, so on, so on. Okay? All right. Other questions? All right, moving on. Let us pause for a moment of reflection. So, Article 3 provides jurisdiction over cases or controversies. Okay. State law claims that do not have pre-existing subject matter jurisdiction can tag along with claims that have federal subject matter jurisdiction as long as they're part of the same case or controversy. You have to have that original jurisdiction claim for 1367A even to operate. So here is the question. Does 1367A operate differently depending on whether the basis of federal subject matter jurisdiction is arising under, so that's section 1331, or diversity, section 1332? Okay. Mr. Fogg,
Yes.
is there a difference between these?
I'm not sure.
Okay. Mr. Knapp,
I don't think it would matter, right? Because as long as it's over the same 5,000 and the parties are domiciled in different states, I don't think it would matter. You can bring any claim you want.
right. 1367A does not care whether this is federal question jurisdiction or diversity jurisdiction. Okay. All it asks is, does the original jurisdiction claim have the same nucleus of operative fact as the supplemental jurisdiction claim? If the answer is yes, then 1367A says, great, you can move forward. Okay. So this is something I want to hammer this just a little bit because this is a question that you are going to be asking yourself again and again and again as we proceed through the rest of this chapter. Okay. For 1367A, we do not care what the basis of subject matter jurisdiction is. Now, let me complicate your life a little bit. Let us look at 1367B. Ms. Gleason, given your understanding of 1367A and 1367B, what is the statutory language that supports these statements on the screen?
Before I answer, can you tell me, is this one of the DRQs or am I supposed to take this answer out of my head?
This is a DRQ.
Can you tell me the number? Is it 8?
Nope, it's 9.
So this is what I wrote. Section 1367A provides jurisdiction for a claim, the sprinkle, that standing alone would not have a jurisdictional basis when the claim is so related, there's your language, to a claim for which, quote, original jurisdiction exists. There's your ice cream cone. If both claims are so related or they share a common nucleus of operative fact, then they form part of the same case or controversy under Article 3, and there is jurisdiction over the entire case or controversy. 1367B is a takeaway of the jurisdiction provided in 1367A that operates only in certain situations when the sole basis of original jurisdiction over the ice cream cone is diversity jurisdiction.
So, more or less, this is exactly what the DRQ is saying. What I'm looking for, Mr. Henninger, what I'm looking for is what is the statutory language? And I will say, right, Ms. Gleason gave us the statutory language for 1367A. So Mr. Henninger, I'm going to point you to 1367B. What is the statutory language that makes this comment correct?
Well, it says the district court shall not have supplemental jurisdiction, so that way it's a takeaway.
Right.
When it's, you know, claims by plaintiffs that may be parties under such and such rules.
Mhm.
So that's where you get the takeaway. And also claims by plaintiffs joined under Rule 19.
Right. So, and what about this last part here, where the basis of federal subject matter jurisdiction is diversity jurisdiction?
Is it when it says when they have jurisdiction found solely on section 1332?
Right. Okay. So Mr. Henninger is correct that 1367B says in diversity cases where solely the subject matter jurisdiction grant is diversity, that claims where the grant of jurisdiction is 1367A may not be heard if they are brought under certain situations. And what are those certain situations? Mr. Gonzalez.
That'd be situations where persons would be made parties under Rule 14, 19, 20, and 24, which are intervening as a plaintiff under Rule 24. The other ones.
20 is permissive joinder of claims.
20 is permissive joinder of claims. 19 is required joinder of claims. 14 is third-party practice.
Right. Okay. So, okay. So we're going to spend on Thursday a lot of time sort of working through the mechanics of how these connections of joinders of claims and joinder of parties affects the grant of supplemental jurisdiction. But for now, we can pause here with the recognition that 1367A is limited by the capacity of parties to use joinder to circumvent diversity. Okay. Basically, the whole idea behind 1367B is that we don't want cases going into the federal courts for diversity purposes and then using manipulation of the joinder rules to drag in claims that would destroy that diversity jurisdiction. Okay. All right. We are out of time. However, if you have, we're actually well out of time. If you have questions, office hours are tomorrow. So feel free to come and see me. All right. Thanks so much, guys. We'll see you Thursday.
Yeah.